Hi, welcome to Chapter 3. Chapter 3 of this textbook looks at some of the common law issues surrounding the employment process. And whenever we go and hire someone or whenever you accept a job, there are some issues that you need to be aware of that could, in fact, null and void the job. We're going to take a look at several of them in this chapter. The first one is the concept of misrepresentation. Misrepresentation could be from the employer's perspective or the employee's perspective, and essentially what it is a white lie. And that white lie could influence how well you can do the job or how well you're qualified for the job, or it could influence your decision to keep the job or not. So from an employer point of view, the employer must be cautious not to misrepresent the job. Tell it the way it is, tell the truth about it. Don't make it too hot and too good for someone to be true, because if it isn't true, that would give them an opportunity for redress. From an employee's point of view, you want to make sure that everything you got on your resume is the truth, and so it's that you don't give your employer a sense that you are something that you're really not, because that could end up costing you your job. In terms of the law and what the law has ruled on this, 5 major criteria has been laid down in order to establish misrepresentation. First, there must be a duty of care based on the special relationship between the parties. We have to ensure that a witness, there is a duty of care not to mislead the other guy. The representation must be untrue, inaccurate, and misleading. If it is those things, then we call it. Then we can call it misrepresentation. Defendant must have acted negligently in making the representation. In other words, it can't be an honest mistake. It has to be a directed mistake, that basically a lie. The plaintiff must have reasonably relied on the misrepresentation. So from the employer or the employer's perspective, you were told something that you relied on to either hire someone or to accept the job, and if that cost you money in terms of what you thought you were getting and what you really got, then you have a reason for action. The plaintiff must have suffered some form of loss or damage, and again, there has to be some quantifiable loss or damage in order to be able to get misrepresentation straightened away. The next issue we look at is this concept of inducement. And inducement means that you were induced actually to take a job or to do something that you normally wouldn't do. So anyone who's been given too much of an inducement to come to a job could have recourse to say, you know, you made it so wonderful and so great, I'm now here and it's not as good as what you told me it was going to be. As a result, now I'm breaking the contract. Restrictive covenants, and these are documents that are written up whenever the person is hired. It basically says if you were to leave us, you can't do something. You can't work for a competition, or you can't set up an identical business, or something like that. Restrictive covenants were pretty common. Courts haven't looked up on them too well, but essentially what it does is it restricts your ability once you leave the organization to do something. Anticipatory breach. An anticipatory breach, as the name suggests, is an anticipation that you're going to breach your contract, and it will be found where a party's conduct amounts to a total rejection of the obligations under the contract. So you hired me to shovel your driveway, and I basically haven't come and shoveled your driveway. That could be considered some sort of anticipatory breach. The very fact that I haven't done it means that I'm not going to do it. The test for anticipatory breach, known as repudiation, is whether the threatened breach deprived the injured party of a substantial part of the benefits of which he's entitled to under the contract. So if I'm supposed to shovel your driveway, I don't, and your driveway is full of snow, you can't get out, these sorts of things, that would be considered an anticipatory breach, because you've suffered. And courts will look at 5 factors used to determine whether the conduct was has deprived, and that would be the ratio of the party's obligations not performed to the party's obligations as a whole, but how much of this is the total. The seriousness of the breach to the innocent party, the likelihood of repudiation of such a breach, the likelihood of repetition of such a breach will happen more than once, the seriousness of the consequences of the breach, and the relationship of the part of the obligation performed by the whole obligation. You know, how important is this part relative to the rest? In terms of reference checks too, we also look at that, and that is before you hire someone, you're going to do a reference check on them. What are the obligations to the reference checks providers and you when you conduct a reference check? And there's a bunch of points there, thinking about potential bias or several issues with regards to getting good solid information, and what happens if you're not fed good information. What are the implications of that? One of the key things that's in this section that you really need to concern yourself with is the distinction of an employee versus an independent contractor. And in law and in any cases like this, we really need to concern ourselves with clarifying what exactly is meant by an employee. So this the section that is relating to that kind of focuses on some key things. First of all, what is an independent contractor by definition? Well, an independent contractor is someone who does a specific set of work for a company and then is released from the contract. So by nature, there's not an ongoing relationship. So an independent contractor comes, does a job, and leaves. An employee, on the other hand, is someone who is there in a longer term to perform a task that is continuing. Now, from a Revenue Canada perspective and from a legal perspective, that distinction is important, because what happens with independent contractors is that there is no need for the employer or the person that's paying the bills to record or to pay source deductions. So if there are no source deductions taken, that means that taxes aren't collected, workers' compensation is not paid, EI eligibility is not there. So again, government and business should be very interested in determining whether someone is independent or an employee. Now, what you need to concern yourself with is what constitutes an employee. What are some of the basic tests? Well, there have been many court rulings on this, and essentially the test to determine if someone is an employee or an independent contractor is broken down into 5 major categories. 5 major things will help determine if someone is an employee or an independent contractor. First and foremost, there's the control test. The control test effectively says, is that individual that's doing the work under the control of the employer? Meaning, do they have to come in at set hours? Do they get to leave at a certain time? Do they have a specified day and a specified time and a specified place that they do the job? If all those things are specified, we say that the employer has a good bit of control over the person, and that person then is more likely to be considered an employee. The next thing is the risk test. If I'm an employee, I take no risk, meaning I'm going to get paid whether I do the job, or if the job works, or if the job doesn't work, I'm going to get paid. An independent contractor, on the other hand, takes on a certain degree of risk. The contractor has to do the job. If the job is not done, the contractor doesn't get paid. If something goes wrong that makes it impossible to do the job, the contractor doesn't get paid. So the contractor takes on a certain degree of risk, whereas an employee really doesn't take on any risk whatsoever. The next issue is the organization test. And the real test there is looking at, is that individual part of the organization? Is that individual ingrained into the operations of the organization? So the services that are rendered by the individual need to be integral. Are they part of the business? If they're part of the business, so for example, if you're in a school and you're a teacher, that will be considered integral to the operation of the business. Odds are, in that case, you would be considered an employee, or work towards pointing that you're an employee. We also have the tools test. From a tools test point of view, an independent contractor usually supplies their own tools, whereas an employee is usually supplied the tools to do the job. So we look at the tools and we say, now, is this person bringing their own tools, or are the tools supplied to them? If they're bringing their own tools, it would suggest that the person is more likely an independent contractor. If the tools are supplied, they're more likely to be considered an employee. Finally, we look at the durability test. And an independent contractor could be independent, but be working for the same organization in a long-term contract. So let's assume that if that contract goes on for a year or more, government, Revenue Canada, other agencies will look at that and say, look, This relationship is so long-lasting and so durable, the durability, that it is as well to say that person is an employee as anything else. You can't really be an independent contractor and work indefinitely at a place. So you need to be able to demonstrate, if you're an independent, that you're not there in a long-term capacity. So be aware of those 5 measures, and be aware that employers need to be to assure themselves that if they're going to claim that people working for them are independent contractors and not employees, they have to assure that they meet those standard tests. Okay, well that's the key things that you're going to be looking at in this unit. I think that we've covered all 3 of them fairly well now. You want to give it all a good review. And if you got any questions or anything like that, please don't hesitate to email me or call me. Thanks very much.